The update that should terrify every American who believes the Supreme Court is the final word on the law. In May 2025, all 9 justices of the United States Supreme Court, from Clarence Thomas to Sonia Sotomayor, issued a rare, unanimous decision that was supposed to change how police use force in America forever. Conservative justices, liberal justices, moderate justices, all 9 of them voted exactly the same way. That almost never happens anymore, which tells you how clear this issue really was. But here's what almost nobody is talking about. Just 4 months later, the exact same courts that the Supreme Court overruled found a way to reach the exact same conclusions they reached before. Multiple states and police departments across the country are quietly working around this ruling. And this isn't an isolated incident. We are witnessing something that legal scholars are calling a constitutional crisis, a systematic pattern where 9-0 Supreme Court decisions are being treated as suggestions rather than commands. Hit that subscribe button right now because what I'm about to show you affects every traffic stop, every government interaction, and every constitutional right you think you have. If you think a unanimous 9-0 decision from the United States Supreme Court is the final word on the law, you are living in a reality that no longer exists. For over 2 centuries, a 9-0 ruling was the nuclear option of the American legal system, a signal that the highest court in the land was in total agreement, leaving no room for debate, no room for delay, and certainly no room for defiance. But as we sit here in 2026, that foundation has just been rocked. And I'm going to prove it to you using a case that affects 20 million Americans every single year. Hi, I'm Sophia, and today we're breaking down a story that most major news outlets are either missing or too afraid to touch. We're going to look at the Supreme Court case that changed everything, how it's being systematically defied, and most importantly, why this creates a dangerous precedent that affects every single American regardless of your political views or how you feel about law enforcement. Let me start by telling you about the case at the center of this constitutional earthquake. In May 2025, the United States Supreme Court issued a unanimous decision in Barnes versus Felix. Here's what happened. Back in 2016, a young man named Ashtian Barnes was pulled over by Deputy Constable Roberto Felix outside Houston, Texas for toll violations. Yes, you heard that right. Toll violations. Not a violent crime. Not drugs. Not weapons. Outstanding tolls on a rental car that wasn't even registered to him. During that traffic stop, Barnes was ordered to exit the vehicle, but instead of getting out, he turned the ignition back on and the car started moving forward. Deputy Felix then jumped onto the car's door sill, yelled, "Don't move," twice, and fired 2 shots inside the vehicle, killing Ashtian Barnes. The entire encounter from the moment the car started moving to the moment it stopped was 5 seconds. Just 5 seconds. And within those 5 seconds, only 2 seconds passed between Felix jumping on the car and firing his first shot. Now, Barnes's mother sued, claiming excessive force. And here's where things get really interesting and where we see the first signs of what I call the compliance gap. The lower courts threw out her case using something called the moment of threat doctrine. This doctrine said that courts should only look at the precise 2 seconds when Felix was on that door sill, when he claimed his life was in danger, and ignore everything else that happened before. They wouldn't consider how Felix approached the stop. They wouldn't consider his tactical decisions. They wouldn't look at whether jumping onto a moving vehicle was reasonable in the first place. Just those 2 seconds. And based on those 2 seconds alone, the court said Felix was justified. The Supreme Court looked at that analysis and said absolutely not. In a unanimous opinion written by Justice Elena Kagan, all 9 justices rejected the moment of threat rule and said courts must consider the totality of the circumstances. Everything that happened, the entire context, not just the final split second. Justice Kagan wrote that no rule that excludes consideration of prior events in assessing a police shooting is compatible with the fact-dependent and context-sensitive approach the Fourth Amendment requires. Now, you might be sitting there thinking, okay, so the Supreme Court said to look at all the circumstances. That seems pretty reasonable. What's the big deal? Let me explain why this decision was supposed to be absolutely massive and change everything. Before this ruling, 4 federal circuit courts covering states like New York, Virginia, North Carolina, South Carolina, Texas, Louisiana, Mississippi, Arkansas, Iowa, Minnesota, and Nebraska, that's roughly 1/3 of the entire United States, were using this narrow moment of threat rule, only looking at that final split second and ignoring all the decisions police officers made leading up to the use of force. The Supreme Court's unanimous decision was supposed to end that practice immediately. When the Supreme Court rules 9-0 on a constitutional issue, lower courts are supposed to follow that precedent without question. It's binding precedent. It's the law of the land. There's no ambiguity. There's no wiggle room. Every federal court, every state court, every judge in America is supposed to apply the totality of circumstances test going forward. Period. End of story. That's what everyone expected would happen. Legal experts, civil rights organizations, police accountability advocates, they all thought this was finally the decision that would force courts across the country to take a harder look at questionable police shootings. This was supposed to be the breakthrough moment. But here's what actually happened, and this is where we see the exact same pattern of defiance playing out across multiple areas of law. Let me tell you what happened in September 2025, just 4 months after the Supreme Court's unanimous ruling. The Fifth Circuit Court of Appeals, the exact same court that the Supreme Court just overruled, issued a new decision on the Barnes case when it came back down to them. Remember, the Supreme Court said use the totality of circumstances and sent the case back. So what did the Fifth Circuit do? They looked at the totality of circumstances like they were told, and then they still ruled in favor of Officer Felix anyway. Think about what that means for a second. The Supreme Court unanimously told them their analysis was wrong. All 9 justices said you cannot use the moment of threat rule. And when forced to use the correct legal standard, the Fifth Circuit reached the exact same conclusion they reached before. They found a way to get to the exact same result using different words. This is what I call the vagueness trap, and it's becoming the newest weapon in defying Supreme Court orders. And the Fifth Circuit isn't alone. This pattern of creative compliance is spreading across the country. Look at what's happening in police departments across those states. I've been researching training materials, policy changes, and internal guidance documents. Many departments are continuing to train officers using essentially the same tactical approach they used before. They're telling officers, yes, the legal standard for how courts evaluate your use of force has changed, but your decision-making process in the moment doesn't need to change. Now let me show you the 3 tactics being used to systematically defy 9-0 decisions. Once you understand these, you'll see them everywhere. The first tactic is the vagueness trap. When the Supreme Court issues an order, agencies and lower courts pick apart the exact wording to find wiggle room. In the Barnes case, courts now acknowledge they have to look at all circumstances like the Supreme Court said, but then they frame those circumstances in the most favorable light for the officer. Instead of saying, Officer Felix made a questionable tactical decision by jumping onto a moving vehicle, they say, Officer Felix faced a split-second decision between multiple dangerous options during a traffic stop that could have resulted in a high-speed chase endangering the public. See what happened? They looked at the totality of circumstances. They technically followed the instruction. But the way they characterized those circumstances completely changed the analysis. Same facts, different framing, different outcome. I've seen this exact tactic in other 9-0 cases. In one deportation ruling, the court ordered the government to facilitate someone's return. Government lawyers argued that facilitating doesn't mean ensuring a return, just asking for it. When the foreign government refused, agencies shrugged and said, "We tried, our hands are tied." By claiming the language is vague, they neutralize a unanimous Supreme Court order. The second tactic is the jurisdictional shield. This is a strategy that should send a chill down the spine of every American who values their constitutional rights. In the Barnes case, courts are refusing to question officer tactical decisions by saying, "We're not going to second-guess officer tactics with the benefit of hindsight. Officers have to make quick decisions under stress." The Supreme Court specifically rejected the moment of threat rule to allow examination of those prior choices. But courts are finding ways to avoid that examination anyway by claiming they won't judge officers with 20/20 hindsight. This creates a dead zone where constitutional violations can occur but can never be meaningfully reviewed. I've seen this exact same tactic in the deportation context. The government argued that once they move someone across a border, even if they do it by mistake or illegally, that person enters a legal dead zone. They told the Supreme Court that the moment a person is handed over to a foreign power, U.S. courts lose the authority to order their return. Think about the implications of that logic. If the government can accidentally deport a citizen or legal resident and then claim they have no power to fix the mistake because the person is now on foreign soil, then the government has found a way to extinguish your constitutional rights simply by moving your physical body. Justice Sotomayor warned about this exact scenario, noting that this view implies the government could deport anyone, including U.S. citizens, without legal consequence, as long as they do it before a court can intervene. Whether it's a police officer creating a dangerous situation and then claiming self-defense, or an agency moving someone beyond the court's reach and then claiming no jurisdiction, the pattern is the same. Create the crisis, then use the crisis as a shield. The third tactic is the slow walk. When a court issues an order with a deadline, agencies file for emergency stays, clarifications, and reconsiderations at the last second. By the time the legal dust settles, the deadline has passed and urgency has been drained away. In one case, a Chief Justice had to enter an administrative stay just to handle the volume of last-minute filings. By the time they sorted through everything, months had passed. The news cycle had moved on. Mission accomplished for the agency avoiding compliance. Police departments are doing their own version of the slow walk. They say they need time to review policies, update training, consult with legal counsel. And while time passes, officers continue using the same tactics the Supreme Court decision was meant to change. The deterrent effect disappears. Now let me be very clear about why this matters to you personally, even if you've never had a negative interaction with police in your entire life, and even if you think deportation cases don't affect you. The implications of this systematic defiance are absolutely massive, and they create what I call a patchwork of justice across America. First, think about the sheer numbers. There are over 50,000 traffic stops every single day in the United States. 20 million civilians get pulled over by police every single year. That's 1 in 15 Americans. Traffic stops are the most common interaction between police and citizens in this country. The Barnes decision was supposed to make police think more carefully about their tactical decisions during these routine stops. If courts have to look at all the circumstances, officers might be more hesitant to escalate situations unnecessarily. That was the theory. But if courts in 1/3 of the country are still finding ways to justify questionable uses of force, even when they look at all the circumstances, then officers aren't getting that message. Nothing changes. Second, this creates a patchwork system of justice that the Supreme Court specifically said shouldn't exist. If you live in states like California, Arizona, Oregon, and Washington, courts were already using the totality test before Barnes. If you're involved in a police encounter there, you have strong constitutional protections. But if you live in states covered by the circuits that used to follow the moment of threat rule, your constitutional rights might be worth less in practice, even though the Supreme Court said they should be worth the same everywhere. That's not how constitutional rights are supposed to work. The Fourth Amendment means the same thing whether you're in California or Texas or New York or Mississippi. Your right against unreasonable searches and seizures shouldn't depend on which federal circuit you happen to be standing in when police approach you. But that's exactly what's happening right now. Because the Supreme Court recently limited the power of universal injunctions, we are entering an era where a law might be unconstitutional in Maryland but perfectly legal in Tennessee. This patchwork means that your rights depend entirely on your zip code. Third, and this is what keeps me up at night, we're seeing the death of precedent. If 9-0 rulings can be ignored or worked around, then settled law no longer exists. This makes it impossible for you to plan for the future. Whether it's your taxes, your small business, your property rights, or your interactions with police, you can no longer rely on a court victory to protect you permanently. Winning in court becomes only half the battle. You now have to fight through what I call the compliance phase, where you spend thousands or millions of dollars on follow-up lawsuits just to get the government to do what the court already ordered. Let me give you a concrete example of how this affects everyday people. Imagine you win a major lawsuit against a government agency for overtaxing you. The Supreme Court rules in your favor 9-0. You think you're done. But then the agency claims the court's order was vague about the timeline for refunds. They slow walk the implementation. They file for clarifications. They argue about jurisdiction. Meanwhile, you're still out that money. You have to hire lawyers again. You're back in court fighting over what everyone thought was already settled. Your victory is hollow. You have the right on paper, but you don't have the freedom in reality. Now, you might be wondering, what happens when the highest court in the land gets tired of being ignored? The law provides what I call the nuclear button, contempt of court. In 2026, we are hearing more and more legal scholars discuss the possibility of courts holding high-ranking officials in civil or even criminal contempt. We've seen hints of this before. In 2019, a Secretary of Education was found in contempt and fined $100,000 for violating a student loan order. In 2022, a state court held a former president in contempt for failing to produce documents. But here's the constitutional dead end. If a judge orders the arrest of a federal official for refusing to comply with a 9-0 ruling, who carries out that arrest? Typically, it would be the U.S. Marshals. But the Marshals are part of the Department of Justice, the very agency that is often doing the defying. If the executive branch controls the hand that enforces the law, the judicial head has no way to make the body move. This is the ultimate catch-22, and it reveals just how fragile our system of checks and balances really is. Let me also address something the Supreme Court specifically and deliberately refused to tackle in the Barnes decision, because this gap is being exploited right now. Justice Kagan wrote very explicitly, "We do not address here the different question whether or how an officer's own creation of a dangerous situation factors into the reasonableness analysis." The court said that issue wasn't properly before them, so they weren't going to rule on it. This is huge, because the central question in cases like Barnes is often whether the officer created the danger in the first place. Did Felix create the dangerous situation by jumping onto the car, or did Barnes create it by starting to drive away? That's a critical question. And the Supreme Court punted on it completely. Lower courts are now using that gap to continue deferring heavily to police. They're saying, well, the Supreme Court didn't tell us how to analyze officer-created danger, so we're going to keep giving officers the benefit of the doubt on their tactical decisions. This is exactly the kind of analysis the Barnes decision was supposed to prevent. But because the court left this one issue unresolved, it's become a massive loophole. I've talked to police training instructors, and some of them are frustrated by this disconnect. They're saying, we know the law changed, we know courts are supposed to look at more factors now, but our department leadership doesn't want to overhaul our entire training program. They don't want to suggest that what we were doing before was wrong. So we're making minimal adjustments and hoping it's enough. That's not good enough, not for constitutional rights that the Supreme Court unanimously said need to be protected. So where does all of this leave us? What do you need to understand as we move deeper into 2026 and this era of systematic defiance? Here's my honest assessment and my action plan for you. First, don't assume victory. If you are involved in any legal dispute with a government entity, whether it's a police encounter, a tax issue, a property dispute, or anything else, winning in court is only half the battle. You must now plan for the compliance phase, budget for it, prepare for it. Expect agencies to use the vagueness trap, the jurisdictional shield, and the slow walk. Document everything. Keep records of every deadline missed and every excuse given, because you may need to go back to court multiple times to enforce what you already won. Second, stay informed locally. Because universal injunctions are being scaled back, pay close attention to the rulings in your specific federal circuit. What is legal in the next state over may not protect you at home. Know which circuit you're in. Know how that circuit has responded to major Supreme Court decisions. Your rights increasingly depend on your geography, and ignorance is not bliss in this new landscape. Third, support transparency and demand accountability from your representatives. If a 9-0 decision can be ignored without consequence, the legislative branch must step in. Congress has the power of the purse. They can withhold funding from defiant agencies. They can hold hearings. They can pass laws that close the loopholes being exploited. But they will only do this if constituents demand it. The enforcement gap I've been describing won't close by itself. Fourth, understand that this double standard is the greatest threat to our system. We are living in a world where automation is making the law stricter for citizens. DMV rules are applied with ruthless efficiency. Tax deadlines are enforced to the minute, and ordinary people are expected to comply with every regulation or face immediate consequences. But at the same time, the government is finding ways to make the law looser for themselves. They get to interpret their obligations as suggestions. They get to slow walk compliance. They get to claim vagueness in jurisdiction and administrative impossibility. This is not how a constitutional republic is supposed to function. The Barnes decision was supposed to be a watershed moment. 9 justices across the entire ideological spectrum agreed on what the law requires. The same is true for other unanimous decisions being defied right now. These should have been moments when the country took a breath and said, "The law has spoken." But instead, they became the beginning of a new and more dangerous conflict between the branches of government, and you and I are caught in the middle. What we're seeing right now is a perfect example of the gap between what the law says on paper and how the law operates in practice. The Barnes decision says one thing. Unanimous deportation rulings say another thing. But the reality on the ground, in courtrooms and police departments and federal agencies across America, is very different. If you're someone who cares about constitutional rights and the rule of law, this should be deeply concerning regardless of your politics. A unanimous Supreme Court decision is being defied or worked around in ways that undermine its core purpose. And here's what really worries me. This defiance is being normalized. When the government ignores the Supreme Court and nothing happens, no one goes to jail for contempt, no budgets are cut, no officials are fired, the rule of law becomes a rule of compliance. And the government is choosing not to comply. Once that becomes accepted, once we all just shrug and say, that's how things work now, we've crossed a line that will be very difficult to come back from. A 9-0 decision should be the end of the argument. It should be the moment of consensus that gives all of us clarity about our rights and obligations. But today, it's just the beginning of a new battle. And the casualties in that battle are the everyday Americans who thought they could rely on the Supreme Court to protect them. My goal is to make sure you aren't surprised by these shifts. By understanding the vagueness trap, the jurisdictional shield, the slow walk, and the patchwork of justice, you are better prepared to navigate a world where the rules are changing faster than the textbooks can keep up. You now know that 9-0 doesn't mean what it used to mean. You know that winning in court doesn't guarantee the outcome you were promised. And you know that your constitutional rights may depend more on geography and persistence than on the words written in the Constitution itself. Drop a comment below and tell me, have you or someone you know had an experience with police or another government agency that made you think about these issues? Do you think courts are right to give officials wide latitude in interpreting Supreme Court orders, or should there be real consequences for defiance? I really want to hear your perspective on this because it's a complicated issue with valid concerns on multiple sides. If this video opened your eyes to something you didn't know was happening, smash that subscribe button and turn on notifications so you never miss critical updates about how Supreme Court decisions are actually being implemented in the real world. Share this with every person you know who cares about constitutional rights, police accountability, or the rule of law, because this information could be crucial the next time any of us has an encounter with government power. Stay proactive, stay prepared, and most importantly, stay informed. Knowledge is power, but only if we share it and hold our institutions accountable for following the law the Supreme Court just unanimously laid out for them. I'm Sophia, and I'll see you in the next update.